Greetings, everyone, and welcome to this is Module 7. We're very near the end of this course. As I always say, please, if you're behind in one of your assignments, please catch up quickly because we're really reaching the end. You will have an assignment for this Module 7, but you'll have no written assignment for Module 8. You're asked to do the readings and view the uh, materials that are provided in Module 8, but primarily after Module 7, you're working on your research paper. I need to see your abstract and paper topic, if not already submitted for approval. Please do so. That means your basic the topic that you're proposing. If you're undecided, you can send me more than one suggestion, and also an abstract, which is a kind of a brief overview or description of what you're going to be presenting. And then, in addition, some of the resources that you're going to refer to in doing your research. So just be sure that's all there in the announcement that I sent out earlier. So please focus on getting that to me. Just send it to my email, t.walsh@hji.edu. Thank you. And in this module number 7, we're going to be looking at international law and criminal law, and you've got quite a few readings to cover. And in addition, I'm recording this lecture, which you're now watching. So it's been a great class. We're getting near the end, and the final term paper is the biggest project of this course. So don't forget that point and give good attention and effort at doing well on that. And again, get me your topic, suggestion, proposal, an abstract. Just 150 words is enough, just so I get the basic idea of how you're going to approach your topic. And then some of the sources that you're going to be looking at, both journal articles, scholarly journal articles, or books by significant authors, or things that you have found that are relevant and from credible sources that you find online. So with that, let me seek to begin this first PowerPoint. I'm going to kind of try to cover a few PowerPoints as we proceed here. That's not the right one. So let me see how I'm going to do this. I hope you're seeing this. So this is just talking about criminal law in the U.S. Legal system. This here just talks about what are the ways in which in a society you try to keep order and keep the peace, and that's the purpose of your not only your legal system and your rule of law, but also an enforcement system that backs up the rule of law and the legal system or the court system. That is the police system within the state that can enforce the laws if and when necessary. So there is the penal component of how social control in a society takes place, that if you violate the law, you can be incarcerated, you're given a penalty or put in the prison. There's a therapeutic approach, that effort is made less through traditional punishment, but through other means that are more therapeutic in nature, like counseling or social work, that kind of thing. A third is compensatory, where a person that commits crime is forced to pay in some other way to compensate the victim. That can be through a monetary payment. And a fourth is more conciliatory. This would be more associated with something called restorative justice, where there is an attempt toward creating some kind of reconciliation between the parties involved in the commission of some violation or crime. And what is a crime? It's an act or an omission of an act that violates the criminal law, and it gets penalized by the state as a felony, a major crime, or a misdemeanor, a minor crime, and a wrong that deserves punishment because the perpetrator violated public standards of morality and law. And a crime is an act deemed socially harmful, dangerous, one that is specifically defined, prohibited, and punished under criminal law. That's a definition of a crime. Another approach is a violation of societal rules of behavior is a crime as interpreted and expressed by the criminal law, which reflects those, how do we make criminal law, as we've discussed, comes out of public opinion, traditional values, and or the viewpoint of people currently holding social and political power. So these are certain types of definitions of crime. So what's the purpose of criminal law? Well, it's to restrain criminals. So that's why you have police protection anywhere from sporting events to concerts to being on the streets and patrolling neighborhoods to, as needed, use a form of restraint if necessary, or incapacitation of a would-be or an actual criminal. And another is called deterrence, which is to show superior force or power that someone who's contemplating a crime would decide not to commit the crime out of fear of getting caught and punished and facing a worse fate than the outcome. So deterrence is kind of what they call consequentialist assessment, that I evaluate the consequence. I'd like to steal this item from this store, but gee, and it would save me $100. But if I get caught, I'm going to have to go. I'm at risk of getting arrested, and I would have a record. I would have to spend the day dealing with this, appear in court. This is going to cost me much more than $100. So I decide it's not worth the risk. Another aspect of criminal law, and it's a form of deterrence, is denunciation. That it's I guess you'd call the shame factor, that if I commit a crime, I'd like to be seen as a good person. I'd like to have a good record. And yet if I commit crimes, I will face denunciation or shame. I will be shamed, even if I'm not put in prison. Criminal law also aims at rehabilitation. One ideal of the prison system is that it can work to cause the criminal to rethink their way of life, what they've done, to rehabilitate themselves, to determine not to commit a crime when they're released from incarceration. Another fifth aspect of the purpose of criminal law is simply retribution, that it's almost like an eye for an eye. If you committed a crime, it's a crime against your fellow citizens, against the state, and it is necessary that the scales of justice be balanced once again. So your crime has put the scales out of balance. So it is necessary that you be punished in such a way as to return to, let's call it, equal balance. So that's retribution. A simple way to put it is an eye for an eye. If you kill someone, maybe your punishment should be the death penalty, that kind of thing. But in any case, punishment is necessary as as a necessary act of justice, that it would be unjust if you commit a crime that you not be punished in proportion to the crime that you committed. And this sixth bullet point is called restoration. The criminal law is all about restoration, that criminal who did a wrongdoing can be brought to a deepened understanding of their mistake, their error, their moral failure, and the harm that the criminal act produced in others. They have a remorse, repentance, and even some degree of reconciliation with their victim that can result in some encounter between the perpetrator and the victim, and some degree of coming to reconciliation or restoration of that crime. So, in this understanding of criminal and civil law, one issue is who's bringing the action, meaning who's bringing about a legal claim against someone who's violated the law. One is that it is the people who is represented by the prosecutor and the plaintiff who's making the complaint that a wrong has been done and appealing to the court to consider their complaint. The verdict is a declaration of who's responsible, who has the guilt in the case of the criminal violation, and guilt has to be proven beyond a reasonable doubt in a criminal case in your verdict in declaring who's responsible. And is the defendant guilty? Has to be proven beyond a reasonable doubt. In a civil case, the verdict is a declaration of responsibility, but it's called liability, that there's a preponderance of clear and convincing evidence. There are two different standards in the criminal law versus civil law. And finally, in the area of the sanction or the outcome or the verdict and the punishment, the sentencing from the court, in a criminal case, it's some form of punishment, like most often sentenced to a certain period of time in prison. Or in a civil case, it's some form of compensation. Like if you were drunk and you ran into my parked car and I'm suing you for damages, then you will pay me, or your insurance company will pay me enough to have my car restored to what it was before you ran into it. There are limits on criminal law or criminalization, and it has to be within the confines of a constitutional system and the political system and that hierarchy of law that we've looked at, from constitutional law to state law to local law, and that the federal law, the highest law of the land, rooted in the Constitution, is the supreme law of the land. Some of the elements considered in criminal law, one is the mens rea, or what's called culpability, or the mental state of culpability, that the perpetrator has some knowledge and even conscience-stricken realization in the act they are committed. So that's the meaning of mens rea, an important concept in law. Then there's the other element of a crime is the actus reus. These are Latin words, of course, and this is the criminal act. So one's the state of mind and the other is the act itself. So actus reus isn't talking about thought crimes, like I thought about killing someone, or I felt so much anger, wished they were dead or something. That's not a punishable crime. So it needs an actus reus, a criminal act, and it needs this guilty mind or culpable mind or mental state. Uh, the only exception to mens rea is in the strict liability cases where a person can commit a crime unknowingly, like a person can uh, have an accident in the car where they had no intention to do it, no awareness, and in a sense, don't have a sense of guilt or knowledge of committing a crime. Uh, with a crime, there is a result, an outcome. In a murder, of course, or an action or a medical malpractice, there's some result. And there are the attendant circumstances that are relevant to a final evaluation of the extent or nature of the crime. So when we look at this mens rea concept or guilty mind, um, and look at the model penal code, then mens rea includes such things as doing something intentionally or on purpose or knowingly, similar to purposely or intentionally. You know, I knowingly committed this crime. I robbed a bank purpose, purposely, intentionally, knowingly, or the guilty mind is recklessness. I began firing my gun wildly or provoking people to violence recklessly, and this is part of the mens rea. There's a sense of knowing I am going beyond the law. I'm breaking the law. Or there can be this mens rea due to negligence, maybe similar to recklessness, but negligence meaning I failed to properly take care of a part of my property, and someone slipped on the ice and broke their leg, and my negligence may be part of that. I was too lazy or indifferent to care, and that may result in some kind of criminal level of carelessness. So mens rea, so guilty mind. Purposely, again, it's their conscious object to engage in conduct of that nature or to cause such a result. That's mens rea, purposely carried out. The knowingly that they are practically certain that their conduct will cause a prohibited result. If I fire the gun aimed at another person, then I have reason to believe that there's a degree of certainty that that will inflict terrible harm, if not death. Uh, so that there's an awareness of outcomes, of the relationship of cause and effect between what I'm doing and its impact. Recklessly is a conscious disregard of substantial and unjustifiable risk. If I'm driving a car and I have passengers or I have a child in the car and I'm driving wildly and I'm drinking, then I am being reckless, a gross deviation from the standard of conduct that a law-abiding citizen would observe in the actor's situation. And then another aspect is negligence. Negligence means I should have been or I should be aware of a substantial or unjustifiable risk. The risk must be of such a nature and degree that the actor's failure to perceive it involves a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. So that is a definition of negligence, failure to perceive, fail to recognize that I'm putting someone at great risk. Types of crimes, you can say there are crimes against a person, crimes against property and habitation, inchoate crimes, and other crimes. And we'll look a little bit at that. Crimes against the person is physical victimization. These are among the most serious of criminal offenses like homicide, forcible rape, assault, battery, robbery, crimes against the person. And here's some examples in this chart. I think in the interest of time, I'm not going to go through this, but you have this PowerPoint and it talks about different crimes like murder or rape or robbery. Then it goes across the actus reus, what is the result, impact of the action, the guilty mind component, or the knowledge or knowingness and awareness of the crime, the result, and the attendant circumstances. So this is kind of a good overview, again, of these various types of crimes and how it relates to actus reus, mens rea, result, and attendant circumstances. The other type of crime against property, the most common types of criminal offenses. These crimes harm an individual's property, like burglary, criminal trespass, arson, fraud, forgery, etc. And here's a similar grid of the types of crime: burglary, arson, fraud, forgery, theft. And then again, the actus reus, what the impact of the act itself, the guilty mind component, what's in the mind of the perpetrator, what is the actual result, and what are the attendant circumstances of the act. A fourth type are called inchoate crimes. Less crystal clear is the meaning of inchoate, a bit obscure. That has to do something like an attempted crime. I actually tried to commit a crime but failed. Like I was going to poison someone, but they didn't drink the poison. I attempted, I had the mens rea, I knew what I was doing, and I had an anticipated outcome, and I knew that the act would result in a particular consequence. Another is solicitation, in a sense, asking someone else to commit. I hire someone, a hitman, to bring harm to someone else. I aid and abet a crime, or am involved in a conspiracy. These are under the category of inchoate crimes. And here again, we have a table that deals to the types of crimes: an attempted crime, a solicitation to a crime, a facilitation of a crime, aiding and abetting a crime, or being in conspiracy with others to bring about a result, an actus reus, and awareness of knowing, even though I'm asking someone else to do it in solicitation, or I'm facilitating, I'm going to drive the getaway car, or I'm going to work out the plan, or I'm going to distract someone while you do the actus reus. But I'm part of the effort. And so this lists the type of mental awareness and consciousness of the perpetrator, the outcome or result, and the attendant circumstances. Solicitation, we can define with the purpose of promoting or facilitating the commission of a crime. That's what, when I solicit someone, either commanding, encouraging, requesting another person to engage in specific conduct that would constitute such a crime. Again, I may not be the actual person that robs the bank or commits the crime or brings harm to another, but I have solicited it. There are crimes by co-conspirators. And the Pinkerton rule says that each co-conspirator is responsible for any reasonably foreseeable crime committed by a co-conspirator in furtherance of the conspiracy. So even if one person in a group of 5 co-conspirators kills the person in the bank, then the co-conspirators are all accountable. But co-conspirators are only liable if the defendant solicited commission of the particular crime or aided or agreed or attempted to aid its commission. And then here's another classification of crimes against public administration, against public order, crimes against morality, cyber crimes, to other categories of crime in the overall category of criminal law. Here's a case of, of crimes that some recognize as crimes and in other states not, like adultery has been known to be a felony or a misdemeanor in some states. In other places, it has been decriminalized over time. And you can see that here. So here, where there are certain murky areas, are there victimless crimes or crimes that are moral violations, but not actually criminal violations? Let's look briefly at how one might defend oneself when one is allegedly described as having committed a crime. I can try to defend myself by disputing before the court that the elements of the crime have been proven by the state. In other words, if I am accused of committing a murder, let's say, then my defense is that the state has not provided adequate proof that I am indeed the murderer. So the state has the burden of proof. It must prove all the elements of the crime beyond a reasonable doubt. So if you're on a jury, then the judge will say, you have to rule guilty or non-guilty, and your basis of ruling the defendant to be guilty is that the court has proven beyond a reasonable doubt in your mind that this person is indeed guilty. In a trial, the defendant is not obliged to say anything at the trial. You can stay silent or to put in any evidence. But the defendant will normally put in evidence to dispute the elements that have been put forward. But it's the court that has to prove you committed the crime. So you may feel it's best to stay silent because the court, you and your attorney realize don't have enough evidence. So another line of defense is instead of, or in addition to disputing that the court has enough proof, the defendant may introduce additional facts as an excuse or justification, taking an affirmative defense. One could be, I did commit the crime, but it was the right thing to do. In other words, I did kill this person, but it was an act of self-defense. Or that person, I killed them because they were about to kill other innocent people. Another excuse or a way to defend oneself is to say, I don't deny that I did it, but I shouldn't be held accountable. I shouldn't be punished. One would be to say, because of insanity, I have mental incapacity to the extent that I did not know. There was no mens rea, no guilty mind. I simply was out of my mind, or I was under great duress. Like there are cases where someone has been the victim of sexual abuse for years and years, or spousal abuse, and eventually explodes and kills their abuser. And one may claim I was under extreme duress or forms of stress that would be used in defense. So in the self-defense category, that the individual would have a reasonable belief that he or she is facing an unlawful threat of imminent death or bodily injury by an aggressor. And the force used was reasonable under the circumstances. In other words, the counterforce that I defended myself. This is the self-defense. One is that you should first try to flee or retreat if you can, but it should only be attempted if you shouldn't risk your life by fleeing if you're not certain you can safely flee, and the only alternative is to respond with deadly force, then you're okay to do that. And in the castle doctrine, if you're in your house and someone enters there and you have fear for your life, you may use deadly force to deter them. You may kill them. You don't have to retreat from your own home. Can the FBI, Federal Bureau of Investigation, use deadly force? Yes, only when necessary. However, when the agent has reasonable belief that the subject of such force poses an imminent danger of death or serious physical injury. If feasible, a verbal warning to submit to the authority of the special agent is given prior to the use of deadly force. So here's just a chart that you can look at later in more detail about standards for insanity determinations by jurisdictions in the United States. Different states have different law on what constitutes a viable insanity plea to explain the reason for a crime. So in the McNaughton rule, it must be clearly proved that at the time of the committing of the act, the party accused was laboring under such a defective reason from disease of the mind as not to know the nature and quality of the act he or she was doing, or if he did know it, that he or she did not know he was doing what he was doing was wrong. That is, these are mens rea aspects of the insanity plea. Another is irresistible. Defendant knows the nature and quality of the act and that it is wrong, but it cannot forbear committing the act. This may be used in some forms of sexual abuse or pedophilia or something like that may appeal to that kind of defense. And in the model penal code, a person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity to either appreciate the criminality of the conduct or to conform his conduct to the requirements of the law. Mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise social conduct. That's a little bit of elaboration on the so-called stress defense, like the battered person syndrome that I referred to, where there's a cycle of abuse, and there are different cases that have addressed these issues, such as the Norman case or the case of Regina versus Dudley. So with that, I'm going to bring an end to this course. I know it's a lot of content. It's less dealing with human rights broadly or international law and government, but it is related to an important distinction, particularly between international law and criminal law and civil law, which is important in a broad understanding of the nature of law. So I'm going to stop here. I am going to record one more lecture for this module. Thank you for your attention. Always, when you have questions or concerns, in addition to submission of your assignments, you can always reach out to me anytime by email, t.walsh@hji.edu, t.walsh@hji.edu. Thank you, and see you in my next